Hello, everybody. I'm Phil Brandt, President and CEO of AAIM Employers Association, and welcome to This Week at Work.
Welcome to This Week at Work, the only show to pack workplace news, practical HR solutions, and timely insights into every 30-minute episode.
Proposition A, which we have here in Missouri, for a minimum wage change and for paid sick leave. And that has been on the minds of anyone that has anything to do with compensation and or HR administration and paid time off.
People didn't realize that the sick leave measure was so complete and so onerous. Minimum wage is pretty easy. I think most people kind of have an understanding. It's the dollar amount, and then there's an inflation index. This is a 10-page long proposition. The other 9 pages are the mandatory sick leave. It's got a whole enforcement structure. Voters that voted thought it was just minimum wage. They had no idea that they were literally kind of revolutionizing the sick leave in the state of Missouri.
So what's keeping you up at night? Let's face it together now on This Week at Work.
All right, good morning. Welcome back to the program, everyone. And I want to introduce you to my co-host, Burt Garland. He's been absent for a few weeks. Burt, you're looking sharp today. Welcome back to the program.
Thank you, Phil. I appreciate it. Glad to be back. Glad to be off the road for a little bit, although I am in the actual office today because we're doing a program, Olgetree program, a hybrid program, in person and online, going really in depth on the Missouri Paid Sick Leave Act. In fact, that's why I've got my glasses on this morning, because they print this stuff so darn small that my old eyes need some assistance reading this.
You know who does that, Bert? Lawyers do that.
Yes.
Yeah. You know, they don't want everyone else to read it, so they make it really small and difficult to understand for simple folk like myself. Anyway, sure. Hey, so tell our audience that's tuning in how they can still join up for your program. Online only is available. The in-house seating is sold out, but how can they join up for the program?
Yeah, I think the easiest way is if you just go to Olgetree's website, Olgetree.com, or even actually just Google Olgetree Deakins St. Louis breakfast briefing. You'll get taken to a page that'll allow you to register. And Melissa Pesch and I from the office, she and I will be going through the Missouri Paid Sick Leave Act in great detail and get everybody up to speed on the latest judicial and legislative challenges to the new law.
Yeah, it's great. It's going to be a good program. Melissa does a wonderful job. She did part 2 for us here at the AIM office when we did our simulcast. She did a wonderful job. We got great feedback. She's been on the program. If you still have questions, dig in. I know we're having 2 focus group discussions on it, one later today and one tomorrow afternoon, in person only, because I don't think I can facilitate the discussion online. But nevertheless, there's a lot of questions. So we're going to dedicate today's program to that topic and try to answer what questions we can in a short period of time here. I like to call it rapid fire when we're in person. But if you do have questions on that, go ahead and submit those into Bert and I right now. We'll try and address those for you the best we can. Bert, looked like you wanted to say something there.
Yeah, Phil, I'm just curious. I mean, when did we do our first program on the Missouri Paid Sick Leave? Wasn't it in December?
It was in December. It was like December 18th or something like that last year.
Yeah, and I think we had, between online and in person, we had a good couple hundred people. I mean, didn't we answer all the questions way back then and everybody was attuned to what they needed to do?
You know, Bert, here's what I'm running into and this might be a good way to start off the first question, because I thought the answer to your question is yes. Yeah. But here's what I'm running into. I think very few people are saying, oh, I don't know what you're talking about, but there still are a few people going, I'm not sure what you're talking about. And at that point, it's like, well, you better hurry up and catch up. And then there's another group.
I thought we just voted on a minimum wage increase.
That's right. And I think that's the suit.
That was the confusion, because then we had to go and have an episode, I think it was episode 308, where we had somebody from Jeff City come on, and it just confused everything. So maybe it's our fault all along.
No, Nick, never accept the blame unless you're arguing with your wife, okay? All right. Here you go. So that's one group of people. Good luck to that group. Then we have many of our members are in this spot where they're now realizing, hey, I better do something because I was hoping this was going to get delayed, canceled, reversed, whatever. And they were hoping it was going to go away. And all along, we've been saying, no, you need to prepare just in case. And there's still a chance that it might go away or be delayed. We don't know, be reversed or go away. But there's no updates in the legal system from Missouri as of yet. Is there, Bert?
Well, no, there is not.
New updates.
Yeah, I think there is one new strange update that we'll have to talk about. Do you want to do that now?
Quickly, yes.
Okay, so there is the legislation that's been proposed, and attached to the legislation, they tried to do it on an emergency basis so that if it passed, it would go into effect immediately. And the legislation that's been proposed, initially it was to delay the statute. It then got amended to literally repeal the statute, but the emergency component of that failed. And so what that means is that this law could, if the court doesn't stop it, the law could go into effect on April 15 for notice posting, May 1 for starting the accrual and the use. And then if the law passes to repeal it, that would go into effect in August. And so there may be a strange window from May to August where we have to have an interim Missouri paid sick leave policy that may end up going away completely come August. So there is that strange nuance right now.
Yeah, so we'll be in no man's land should that happen for a little while, to use some tennis phrase. All right, so then the third group that I'm running into is the group of individuals that, and I've had several of these conversations just this week with our members, and some of them are saying, oh, well, you know what? And this, I think, is our first question. We already provide at least 80 hours front loaded of PTO, so we're not worried about it. We're okay. And I think that on the surface sounds like you should be okay, but it's really not. There's things you need to consider to determine if there's anything else that you need to do. And so while our listeners are submitting into the chat, Bert, I think I want to start with that question there. That just is for the individuals that are listening to the program and they're saying, we are ready front load at least 80 hours of PTO time as we think of PTO to our employees on day one or on January 1st every year. I don't need to worry about this policy. I'm covered. I'm fine. Let's just start with that. Where would you want to start with that statement?
Yeah, there's two things that come to mind immediately, and the first one is the whole notion of carryover from year to year, payout and carryover. So that's kind of one topic, and then the second topic would be the requirement in the statute that says that the employer, if you already provide a sufficient amount of time to your employees, time off to your employees, that is available to be used, quote, for the same purposes, end quote, and, quote, under the same conditions, end quote, as the paid sick leave law. And so those two concepts really come to mind when you throw that out there.
Yeah. So when we say the same purposes and the same conditions, if putting that into an expanded definition, what that means is if you accrue it the same way. So it doesn't matter how much you give them, your accrue methodology, but it pretty much needs to be followed of 1 hour for every 30 hours of work. Whether that's how we offer it or not, because we exceed, an allotment, there is the potential, and you could do the math that says somebody that's an overtime hog or works just an outrageous amount of hours could potentially exceed the 80 hours that you front load. So it's how you utilize it. Think of my time in attendance. When do I get attendance points, or when do you start tracking my attendance in a way that might be used in a disciplinary way towards me. You can't necessarily do that with my paid sick leave. And then the other part is someone mentioned like bereavement. Our PTO covers our bereavement time, but bereavement's not called out in paid sick time. So the terms and conditions of can I use PTO or paid sick leave if it's combined for reasons that don't fall under the sick leave, but deduct from their bank. That seems to be the big debate because it becomes an interpretation. And at that point, you're going to have to do your own risk assessment. And I think that's maybe your position is maybe that's okay, and probably you have a good argument. However, it's not the way that the law is written today, and there could be risk associated with that. So let's just chat about that, and then we do have some questions come in online here we'll get to as well.
Sure. So, yeah, so Melissa and I, she and I go to blows over this one because I
Hey,
think
don't you mess with Melissa. I'm putting my money on her.
I would too. I would too. So she and I differ on this one a little bit. I think at the end of the day, we both agree that the intent of the statute is that if you are providing an employee with 80 hours every year to use for this purpose, to use for the same purposes, even including other purposes, but they can at least use it for the same purposes of the statute, you've satisfied your obligation. I think that's what the intent of the law is. But I think the law is written very vaguely, and I could see a creative plaintiff's attorney trying to bring a case, and it would likely be a class action type case or a collective action case. And I could see that attorney trying to argue that that your PTO policy, unless it allows for the exact same purposes, and then very importantly, under the same conditions as the paid sick leave, you haven't provided the benefit of the law. And so the same conditions really come into play there. And those are that there's no limits on the accrual. There is an annual use cap, the increments of use. So a lot of times our PTO policies say you can only use it in 4-hour increments or 8 full day increments. So now you may be opening up your existing PTO policy to 1-hour increments or the lesser of 1-hour increments or what your timekeeping system is capable of recording. Carryover from year to year versus payout. No retaliation, compliance with appropriate notice, and then required documentation. And so all of those are the conditions of the paid sick leave. And so, like I said, the concern that I have is that if your PTO policy does not provide for all of this same stuff, then a plaintiff's attorney is going to sue at some point, and they're likely going to bring it as a class action saying that you failed to do this correctly with all of your employees, and therefore you owe them money under the statute.
Yeah.
But at the end of the day, I think they lose that argument in court because I think that the courts are ultimately going to conclude if you provided them the benefit of the statute, what the statute's trying to do, you've complied. But do you want to spend $100,000, $200,000, $300,000 defending that case just to win it in the end?
Right. Exactly right. And that is going to be a risk profile assessment each organization should consider. And that's where HR and leadership are going to have to sit down, maybe even with your legal advisor, and determine what is the right strategy for your business going forward.
Again, I'm trying to stress that I think that if you offer the 80 hours every year, you front load it, and you think that you're done, I don't think that's the case, because if that's your PTO policy, you have to make sure that that PTO policy is unlimited on accrual. Even though you're giving 80 hours, you still have to go through the accrual and calculate the 1 hour earned for every 30. The increments of use, you may need to adjust your PTO policy to allow for usage in the lesser of those 1 hour increments or what your timekeeping system is capable of doing. You're going to have to allow carryover. You might have to pay that out. There's no retaliation provisions. If your current PTO policy has something in there that it needs to be approved before you can use it, and then you have a policy where not multiple people in one department can't be off at the same time. Well, guess what? Under the Missouri paid sick leave law, that's no longer acceptable. And so you have to, what I'm trying to convey is that if you want to do it for the same purposes and same conditions, you may be opening up your entire PTO bank of leave to these same conditions. And you might not want to do that because under the law, they can only use 56 hours in a year. So if somebody gets 120 hours per year, do you want to give them an entire bank? Do you want to open up your entire bank of 120 hours to all of these same conditions?
Right. And so those are the points we're trying to make. And I think that is why we can't just say, well, we provide 80 hours, which matches the carryover amount, we're fine. So there is a couple questions around that I want to get to. We do have two that came in online here that I think don't address what we've talked about so far. And one of those is CBA, those organizations that are under a collective bargaining agreement. There's a time schedule for them that might be slightly different.
Correct. So under section 296.33, it says, with respect to employees covered by a valid CBA that was in effect on November 5, 2024, the law does not apply until that collective bargaining agreement expires. But when a new agreement is negotiated after November 5, 2024, then you need to take that into account when negotiating a new agreement. So anybody who's in negotiations right now, or if you failed to take this into account after November 5, 2024, which was the election, you need to go back and you need to make sure that whatever's in your collective bargaining agreement, that's no longer going to be operative after April 15/May 1 of this year, absent repeal or judicial determination.
Yeah, absolutely. And then another question here is, what is the date for the online breakfast meeting? Today.
It is April 3rd, 2025.
It's today, and I know
Yes.
that's been widely communicated and so forth, but it's still today. You can register online and join the Olgetree team and get some really good information. I know they'll go through it very thoroughly. We've given them plenty of warm-up sessions in that space here at AIM. All right, so let's go back to the same purpose and conditions. And I want to talk a little bit about it can't be retaliatory.
No retaliation.
Right? So, no
Absolutely.
retaliation. So when we're talking about that, this is where we have to look at our attendance policy. And if we're tracking attendance and issuing points, or you're only allowed so many days away with a lack of notice or short notice or unexpected time away, those types of things in our policy, when someone is using, if you do combine it with your PTO, this is where it might affect your attendance policy. You're not going to be able to count those points or those absences in a way that could be retaliatory for employers or for the employee. And I think this is the tricky point, because you're going to be aware of how many hours they've used. But when we've combined our sick days before we had paid sick leave with our vacation days to create a PTO, those are often all-inclusive of both. And now if we just lay another 56 hours of absence time over our PTO time, you might be exceeding the amount of time you want to allow people to leave. And this might be a time that you want to separate that just for the sake because of the no retaliation. So talk to me a little bit about what that means to you, Bert, no retaliation, as you interpret the law.
Yeah, well, and it's even a little bit broader than that. There's, like the FMLA, there's a no interference section of this. And so an employer may not interfere with, restrain, or deny the exercise or the attempt to exercise any right protected under this law. So you can't interfere with anybody trying to use this paid sick leave. And then it says that an employer may not or shall not take retaliatory personnel action or discriminate against an employee or a former employee because the individual has exercised the rights under the statute. And so that means that they have the right to request or use earned paid sick time. They have the right to file a complaint or inform any person about the employer's alleged violation of the law. They have the right to participate in any investigation, hearing, or proceeding, or to cooperate with or assist the Department of Labor in investigations of violations. And they have the right to inform any person of his or her potential rights under that section. And so you can't take any, it says flat out, you cannot take retaliatory personnel action against an employee who exercises their rights. And that would include things like assessing attendance points, providing disciplinary action or counseling, or demoting or terminating employees.
Yeah. So if let's just talk through maybe a standard attendance policy, maybe let's just say, for the sake of simple math, it says, hey, you're allowed to miss work 10 times before you're terminated, right? And at step 7, you get a notice, and you get a written or final written notice, and then you get terminated, whatever the step process is for your business.
Yeah, like so a no-fault attendance policy where you accrue points. It doesn't matter why you're out. You accrue points, no-fault attendance policy.
Right. If you have a no-fault attendance policy, this is going to be kind of in direct conflict with that. Like you don't count these as days away from work towards a no-fault attendance policy. And that's going to be important, because I may want to go back to my no-fault attendance policy and reduce the number of days of no fault. But could that really be seen as retaliatory? I think you can do that the right way, so it's not seen to be retaliatory against all my employees because of the new change.
Yeah, I think there's a way to do that without it being retaliatory for the new law. The new law is designed to protect people who exercise or try to exercise the rights under the statute. If you revise your no-fault attendance policy, that applies to everybody, regardless of whether they have exercised or attempted to exercise their rights under the statute.
Yeah, absolutely. All right. So then the other part is this carryover. And at the end of the year, I have some time left, and we don't pay out our time. We just, we balance it to zero at the end of the year, on January 31st, 12 o'clock, bang, it balances to zero. And then on January 1st, I reload with 80 hours of available time.
And then you're done. Nothing else to do.
There's nothing else to do, right? Exactly. When you hear that, what you're suggesting, what is it that's triggering your thoughts as, okay, yes, if you do that, these are the 2 or 3 things you want to think about?
Yeah. So as we said before, when I hear that, the first thing is that did you carry over from the prior year or not? Because the statute is very clear that even if you're front loading the next year, you still have to either carry over or pay out. And so if you front load 80 the next year, and it may just be an academic exercise, a paper exercise, just a record keeping exercise, you still have to carry over that 80 hours from the prior year if they earned 80 hours and didn't use their 80 hours. You have to carry it over, because if you don't, you have to pay it out. So if you front load that next year, so you then have the 80 hours that they're getting the next year, plus the 80 that you carried over, so they have 160. But the good news is the law says they can only use 56 in a year. So
that's again, good news, is it?
Yeah, so it's academic, or it's a paper exercise, it's an accounting exercise, but you have to do the carryover still.
Yeah.
And so there's a lot of employers that think, like you said, Phil, that look, we front load at the beginning of each year, and therefore we don't need to worry about anything else. Well, that's not true, because if you aren't doing the carryover, and they'll never get to be able to use that time as the statute's drafted right now, but if you don't do that carryover, you've got to pay them out.
Yeah. The other thing with that, last point on that, and I think we're going to have to call it quits here so you can get to your program. And I can see people here asking about the program. They want the event link, all these different things. It's easiest if you go to the Olgetree St. Louis office and look under their events. That's where I found it, and it was pretty simple registration. But all right, it would be maybe a good solid practice until someone else becomes the case study and it determines what the right practice, acceptable practice is in the eyes of the law, is you carry over up to your 80 hours, whatever your bank is, and the company will front load the balance up to 80, right? That's the language I think I would suggest someone to use. So if I have 40 hours left, I carry over my 40, and the company then will front load a balance up to 80.
Yeah, so I think that that's right, that you can do that. You can allow the carryover, and then you can front load the balance. Up
to the amount that you would otherwise provide, like in this case, minimum of the 80 is what we're referring to in many cases.
Well, I guess as you say it, Phil, it does cause a question in mind. Are you discriminating against somebody who used their time, some of their time in the prior year? So that's a question I think I want to digest a little bit.
Yeah. Okay.
Sorry, I don't have a
that's good. I
cut and dry answer for you there.
No, I think that one is. I think it's a balance between, well, I get rid of it and then I front load it, which is just like you say, it's an exercise of accounting.
It is.
It gets to the same place in either way. The language in your policy just says, no, you're allowed to carry over up to 80. Anyone that has a balance less than 80, we will provide them an additional balance up to, but not to exceed 80. And that might, to me, that seems like it's maybe a little middle ground. And I know you need to think through that one a little bit, but that is a question that I have had a couple of times as a way to do the accounting in a more meaningful way that does comply with the law. Again, I don't know if it's right or wrong, but just a thought.
Yeah.
All right, Bert. Any last closing comments on this before we go for the day? I know you can't cover this in 30 minutes, as we both have learned.
Yes, that is correct.
Last thoughts other than join your webinar today, or?
Yeah, and hopefully somebody had asked for me to provide the links. I don't know if Nick was able to get those up and displayed for everybody, but again, if you just Google St. Louis, Olgetree, St. Louis breakfast briefing, and you'll find the link. You'll either find the flyer telling you how to register, or you'll find the actual link on how to register. And Melissa and I will be digging into this for a solid hour and a half today.
Absolutely. All right. Well, don't you let her do all the heavy lifting today, Bert, even though she's more than capable. All right. We will see you either at that morning briefing. We'll see you at our discussion groups tomorrow, or today and tomorrow, or we'll see you back here next week, 7:30 Central Time. Until then, go out and be good to someone. Take care.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment. LinkedIn, YouTube, Spotify, Apple Podcasts, we're everywhere you are. Don't forget you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.